Noise.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
May I? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for something, for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters.
Wow, that's a lot.
All swarming all over Brian Albert's lawn. Literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house.
So I think he's essentially setting up that Brian Albert was in on it. Evidenced by the fact that all of this stuff was going on his property. And he never did anything to assist somebody who he would have an investment in. But I don't know, man. Yeah, if he is a police officer, then why? I would imagine he would get tipped off, maybe, but we'll see.
That day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part, that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and...
I mean, if he's a family friend and he's the lead investigator on the Karen Reed case, and this is prior to the malpractice that we've heard about, then I think it just is more reasonable too that he did contact Albert prior to come in and could explain the reasoning, but I don't know.
Fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the politician. With him, his brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins.
So I guess John, did you say John McCabe?
Also, Karen ever McCabe was all sister-in-law, Jennifer McCabe. Her daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name...
Okay, I think I had it misinterpreted. I'm pretty sure Jennifer is the sister-in-law to Brian Albert. And I thought it was John O'Keefe's sister-in-law earlier. That makes more sense, though, because in the preliminary notes, there was mention of Jennifer having evidence on her phone saying that a couple of hours before John O'Keefe had passed away, she was doing Google searches of how long it takes to die of hypothermia. So we'll see.
Name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert. He was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along lines for Karen. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends.
If that's the case, why not go inside?
John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why.
Why?
Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning.
I wonder if they're going to bring up a defense for the tail light or not, because I would imagine some of the justification could be that it was the weather was getting increasingly worse. She had allegedly backed up into a flagpole, I think, or at least near one, so maybe that could justify like her accidentally hitting it or something. I don't know. I figured he'd mention that by now if he's describing her. Actually, they haven't talked about the black box footage from her car, so we'll see.
You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr.
Seriously?
Laposada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. Laposada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. Laposada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. Laposada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found and will introduce you to Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that the Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late-night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late-night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m. and why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe. She was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence, from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold.
Hoslong.
Now she misspelled the first word. Hos is supposed to be how, but the meaning
Wait,
is
I
the
wonder
same.
if anybody laughed.
How long is Hoslong to die in cold? Hoslong to die in cold. Now she misspelled the first word. Hos is supposed to be how, but the meaning's the same.
Damn, okay,
How long
whatever.
does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. They'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house.
So is this where
Karen
she
was
breaks
staying.
the brake light?
She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car. with that right rear tail light.
But why?
During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you. None. But they'll make the claim.
Weren't there pieces around his body, though?
We'll show you a
I thought they
video
were, I don't know.
of exactly how that taillight was originally damaged. Or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home?
And drunk.
What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car, he'd walked to the house, she was confused, and later...
Give me 1 second. I'm gonna go... I need to take my medicine real quick, but I'll... What's a good video? I need a good video to play. There you go.
Hello everybody and welcome back to the podcast. For today's guest, we have Baby Gronk. Welcome in. You can just see right there. For today's co-host, we have Mike. He'll be replacing Mike because Mike hates me and he didn't want to show up for this episode. And he's sleeping. And then also his father wants to sit in for the episode. So if you could just grab that chair right there. That one. And then just pull up a seat just right there. Yeah, so if he wants to just introduce himself real quick and just let everybody know a little bit about himself, who he is, go ahead.
I'm Baby Gronk. I play football, and that's it.
So you're like a football guy?
Yeah.
Are you a ranked prospect, or you're just playing it in?
I'm ranked.
What's your ranking for your age group?
Overall.
Huh?
Number 1.
You're number 1 for your age group?
Yeah.
What class are you in? Because you're 11.
2031.
Like, so 5th grade?
Yeah.
Okay. This is a question for both of you, because I had a feeling you would want to sit with him. So how do you think these videos will affect your son when he's trying to get a job in the future?
He already has a job. He makes $30,000 to $40,000 a month.
$30,000 to $40,000 a month? So he's making around $360,000 to $480,000 a year.
Yeah.
How are you guys making that money? From what revenue sources?
Content creation.
No, I know, but like from ad revenue, like from where?
You running ads, brand deals. I do a whole bunch of marketing, so I'm making money off the marketing, training people how to run social media. This is the
Oh, you're like a marketing guy.
Yeah.
Okay, and then so you market for other people or just your son here?
For other people. So, the internet it's the new wave, man. I mean, it's like you do interviews.
Yeah.
You know, you make money off this.
Not really. I'm making like 400 a month.
You gotta be making more.
More than that one?
Gotta be.
So, but where is he making 500, close to 500,000 a year from? Because is it like YouTube revenue, or where is he getting that money?
He's just getting it.
But from what revenue sources?
From everywhere.
Like
You know what I'm
sponsorships, revenue,
Yeah.
ad revenue,
Brand deals.
brand deals.
partnerships,
Who's the brand deal for him?
He's worked with Champ Sports. You know them?
The clothing brand.
Clothing. It's a clothing brand, but it's a store. Champ Sports. They usually work with big athletes like your NFL players, NBA players. He's worked with them.
Like Steve Boy.
He worked with Michael Vick's company.
Michael Vick.
Yeah.
That's-
So Hoodie.
We were trying to get him on, but we wanted to do a sit down with him and a dog, and he wouldn't do it. We wanted to sit him down next to a dog.
Yeah, he probably don't want to be around dogs right now.
Yeah, he has a little bit of a history with that one. Okay, so this is also kind of a question for both of you. But just I was watching some of your content in preparation for the interview. Do you think it's inappropriate to have your 11-year-old son make videos with OnlyFans girls?
Not really. You
Well,
know,
why not?
Because at the end of the day, you know, if they ain't dressed, you know, inappropriate, you know, I don't see no harm.
Shut these dorks up. Jeez. I have some breaking news. I think Mark Zuckerberg went on Theo Vaughn.
I have some tour dates.
Actually, hold on. Before I get too distracted, I want... Okay. Why do they speak for so long? Come on. Okay.
Later, when she found him at 6
I can do this. I will do this. There's like 8 minutes left.
a.m. on the lawn, when she
I'll
last
speed
saw
it
him
up.
going toward the house, her mind started reeling, oh my God, did a plow hit him?
Oh my God,
Did
oh my
I hit him?
God.
Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he literally did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about.
Oh.
Your job will be to make sure that the evidence isn't presented to you too cute by half.
Okay, not being more than...
She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and other people in the Commonwealth. Very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other. A woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mulaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Roby, McLaughlin.
Jesus Christ.
Jennifer McKay, they were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, I hit him. Not one. Not one civilian reported having heard Karen Reed say, I hit him.
I guess they're honing in on the idea of a civilian mentioning it, if they're building the case that the state or the representative of the state is the one that is covering up on behalf of the I guess on behalf of the state, if the police department is the one that they're alleging is the one that's actually responsible for killing John and then framing it on Karen. But I still don't think, maybe I'm just extra tired today, I don't think they've established a reason why they would kill John. Besides potential jealousy from Brian Higgins. Because I know they like briefly mentioned the confrontation or something like that on the surveillance footage of the second bar that they attended, but then they moved past it. So I don't know.
The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother.
Oh my god.
And remember, Chris Albert, the other brother, is the board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long, close personal friends with a young woman named Caitlin Albert. You heard that right.
Oh my god.
During the course of this trial,
That's crazy,
you'll
dude.
realize the Alberts are indeed
That's
a powerful
crazy,
and
Jackson.
indeed an influential family, and that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, along with John's phone, along with video footage, along with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero. Nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV, and the evidence will give you the answer. All. That's Michael Proctor. And he did it without any...
I'm rewinding it so I can take notes on this part because I was asking earlier what... I wonder if they would make mention of why there were taillight pieces alleged to be found around John O'Keefe's body. And it sounds like he's describing this now.
Reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero. Nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up, and not just a few items. 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. Came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. The DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found. John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish, independently, that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented...
Okay, let me write this down. They allege that there is no data shown on the fragments, or I should say fragmented pieces. Only DNA shown to be on the head or the tail light of the car itself. They also allege that there were 5 unidentified, or I say unidentifiable pieces of male DNA that were on John's missing shoe. Okay. I think that's a pretty decent reason to explain, or at least contribute to explaining, as to why he believes the theory that he was carried outward to the snow, but that doesn't necessarily mean that he had to been carried outward, unless I'm misunderstanding something that they had mentioned, or I just didn't hear it, but we'll see.
This exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it. After conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner will call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson.
King. What a king. Okay, I think I'm falling asleep watching that. I woke up late. But I have a fuck ton of notes, so that'll be super cool. I wonder if I can use ChatGPT to condense this in like an accurate and fair way. But that's the opening statement from both parties, and then I believe that they go into the witness testimony with a paramedic. But I'll wait to go into that. I'm going to put on this Theo Vaughn thing just to see, because it looked ridiculous from what I saw. Right here. Let's do picture in picture. What I am curious about, whenever he mentions the examiner refusing to conclude that the death, with the evidence presented by the state itself as a homicide, I'm curious to know what the rate is in which their state in particular does that for vehicular deaths, or the rate in which that happens in the United States overall, and potentially comparing the two. But I also wonder what they would deem to be a death. Maybe like a death that would otherwise not be existent had that other circumstance not occurred, similar to what happened with the COVID deaths, where people were talking about how they're unfairly ruling something to be a death. Like if somebody dies of like a car accident or something, or if somebody gets into a car accident and then dies later on and they have COVID, that either contributes to their body struggling during the recovery process, or even worsens it to the extent that they actually die. I wonder if it's a similar case to that, but I don't know. I guess we'll see. like they might not even determine it to be a death due to the vehicle, but rather due to the trauma itself or hypothermia, or I don't know. But they already said, at least in the defense testimony, that hypothermia wasn't the case. So who knows? Who knows? We're gonna see what this hick has to say.
To tell you about
This
Miami,
hick in the
Florida
bot,
on
hick in the-
Minnesota,
that-
June 20th.
That sounds like almost like a banger podcast, like the hick in the robot.
For the men in the world. Power and VR. Drink coffee, man, or no?
That's the clip I saw actually. Why does he look
Drink
like
coffee,
this?
man, or no?
Nah.
Really?
Yeah,
What the fuck?
I mean, you've had it.
I have. Sometimes on vacation I'll drink it recreationally. It's
He's like a
every once in
rizzed
a while.
out like Tesla bot.
Just like it's like a celebration.
Yeah, no. It's
Really?
Yeah, no. I just like hate anything that messes with like I don't like any kind of chemicals or anything like that.
Oh, really? So you like to keep everything the
Yeah,
equilibrium?
Okay.
Yeah, my sister gives me such a hard time about this. She's like, "You're just sitting there raw dogging reality."
Wow. It's kind of true. Like, so you've had it before, yeah, but you just don't like it.
He's a robot. It
So
does
when you
not
get up in the morning,
count.
that's not your thing. Like, is there something you do?
No. Yeah, I mean, I wake up and I fight people.
Yeah.
Yeah. No, I mean, I wake up in the morning. And,
I am curious
Are
about
we going, by the way? I
this.
mean, we should.
I saw this pop up in my feed, and it's a conversation over jurisdiction that Pisco is having, and since I looked into like the jurisdiction and what determines the jurisdiction of a case, I'm interested to know like what I would know now and the context in which I would view this stuff in. So I'm going to actually rewind it a little bit.
He is a Canadian conservative. He was just on Steve Bannon. I've talked to him before. He's a bit of a legal goober. Sometimes he goes on the goob stream. So we'll be talking to him about Trump's first 100 days. He is pretty pro-MAGA, right? He was upset with Pierre Poilievre from the right. So we'll be talking to Viva Frey. That's tomorrow. I think it'll be around 8 p.m. Just heads up. But I will definitely let you guys know that 8 p.m. tomorrow. And then Saturday's Tim Pool to jurisdiction. Money Club. Let's change that. Boom. Boom roasted. Take off studio mode. Alright. So this is me in.
Alright, so he's having a conversation about jurisdiction versus venue. From my layman understanding, it doesn't seem like sorry, I'm just pulling something up. So I think the argument that Rob had was, I think regarding the deportations lately, it was some argument about one of the courts that was submitting a TRO against the Trump administration did not have the venue jurisdiction to be able to do that. And from my very basic non-lawyer layman understanding is that there is no such thing as a venue jurisdiction, and that there are three main components to jurisdiction. So this could be a case of outliers existing that I'm not aware of, but the jurisdiction refers to three different elements that have to be shown in order for a venue to take, venue refers to the, like, who is hosting the hearings of the charges and whatnot, from my understanding. So there are three elements of a typical question of jurisdiction, and it's the geographic element, so wherever that the alleged charge is happening at, or can be argued for. There is the personal, I believe, jurisdiction is one of the other elements, and that just refers to the person's involvement and if it's deemed legitimate to qualify to be part of the hearing. And the most important is the subject matter jurisdiction, and if the subject matter jurisdiction doesn't even matter, and it's not relevant to what's being alleged at all, then there's no case to be held whatsoever. So one of the main elements, the subject matter, has to be consistent, and it can never be changing throughout this entire process, or else it just falls out. Whereas the personal and the geographic portion of the jurisdiction discussion can be argued in particular ways. So whenever he says that there is a venue jurisdiction, it's not really an element that I am aware of. And they don't, it doesn't feel like a correct term at all either. I don't know how to describe the difference. It's like a venue doesn't have a jurisdiction. I'm trying to like parse it out because it's just so annoying. I don't know how to so it's like a jurisdiction has to be determined, and there are multiple courts that can technically have jurisdiction over a case, and the venue is where it's deemed like most appropriate for that jurisdiction to exist within and can make the strongest case. So venue jurisdiction isn't really a concept from my understanding. It's more like the venue is like improper or inappropriate. And I know I'm rambling, but I want to flesh this out as much as I can personally, so that I can like internally check what is being spoken about. But Rob, the guy that Pisco is going to be debating against, I guess, is the person that was conflating these two and or these concepts. And I want to check my work with what Pisco says. But we'll see.
Good faith presenting my argument. If the habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. That is, H implies not J. The habeas territorial jurisdiction rule is a venue rule, H.
If habeas territorial jurisdiction is a venue rule, then it is not a jurisdictional rule. Okay. Part 2, habeas territorial jurisdiction rule is a venue rule. Therefore, habeas territorial jurisdiction rule is not a jurisdictional rule. Let me look up what jurisdictional rule refers to specifically. I don't know if it's saying that, like, in order for the jurisdiction to apply, it has to follow these elements, or if it means that a ruling by a court or someone that's hired to deem something worthy or appropriate of existing. So, jurisdiction rule meaning the power of a court to adjudicate cases and issues orders. Territory within which a court or government agency may properly exercise its power, exercise its power. So I don't even know if jurisdiction rule is anything that's like meaningfully different from the term jurisdiction overall. So whenever they're referring to habeas territorial jurisdiction rule, it sounds like they're just referring to the habeas. I think typically refers to habeas corpus, which is your right to due process, whereas the habeas corpus petition is a challenge to whether or not your holding or your client's holding is justified, and they're questioning whether or not that is justified. So I think right here they're just referring to the subject of due process and determining whether or not the venue, which would be represented by the territory from my understanding, they're determining whether or not the venue is appropriate in this context to apply the jurisdiction, meaning that it's not a jurisdiction rule. They're trying to determine whether or not it's appropriate to even host it in that venue.
Therefore, habeas territorial jurisdiction rule is not a jurisdictional rule. Therefore, not J. This necessarily follows, right? If P1 is true, and if P2 is true, then C is true. Does anyone disagree that this is a formally valid argument? I wish I were high on pot news. Rob's gonna eat your lunch, says level 4 lobster. So this is just a real answer, right? Just a correct rule.
It seems like it.
Or correct argument, valid argument, I should say. Now, so unless anyone from Rob's community or like the lobster guy thinks that this is not the case, they can try to contest the validity of it. Go ahead. This is the support for P1. Any venue rule is by definition not jurisdictional rule. Okay? So this is Black's Law Dictionary. Here's the definition of jurisdiction that we're using, right? Not the government's general power, but a court's power to decide a case or issue a decree. That's the definition. Here's the definition of venue. One of two, right, that we're going to use here. The other two aren't really relevant. The proper or a possible place for a lawsuit to proceed, usually because the place has some connection either with the events that gave rise to the lawsuit or with the plaintiff or the defendant. Venue. The territory, such as a...
Also, to be clear, I do know that I butcher the explanation and stuff. I just want to make sure for myself that I genuinely am like grasping the concept of what I'm trying to explain. That way I can hold myself accountable, I guess, for adjusting it whenever I need to.
A country or other political subdivision over which a trial court has jurisdiction, right? CF means compare to jurisdiction, right? This is from Black's Law Dictionary. Now read these. I'm gonna see if I can zoom in any more here. If you can't see it, I'm sorry. I'm just gonna read it out loud. These two things underneath them, they're citing two actual treatises, okay? And these are like some of the main guys, Friedenthal and Wright. These are some of the main guys on like federal practice and writing these kinds of treaties. All right. So this is what they say: venue must be carefully distinguished from jurisdiction. That is, venue is not jurisdiction. Okay.
So venue jurisdiction
Venue
does
can't
not
be
exist.
jurisdiction. It's not. Venue must be carefully distinguished from jurisdiction. Jurisdiction deals with the power of a court to hear and dispose of a given case. In the federal system, it involves questions of a constitutional dimension concerning the basic divisions of judicial power among the states and between the states and federal court. Venue is of a distinctly lower level of importance. It is simply a statutory device designed to facilitate and balance the objectives of optimum convenience for parties and witnesses and efficient allocation of judicial resources. Okay? And then this next one. The distinction must be clearly understood between jurisdiction, which is the power to adjudicate, and venue, which relates to the place where judicial authority may be exercised and is intended for the convenience of the litigants. It is possible, this is important, it is possible for jurisdiction to exist, though venue in a particular district is improper. And it is possible for a suit to be brought in the appropriate venue, though it must be dismissed for lack of jurisdiction. So understand that, right? If the holding, it is possible, in other words, for a case to be dismissed because the court doesn't have venue, improper venue, notwithstanding the fact that jurisdiction is proper. Leading treatise writer here, Charles Allen Wright. And by the way, this is not just dictionary definitions. We're about to go to case law after this. That's for the support. But what's being said here is, if you say that venue is improper and the case must be dismissed, it is not a holding that you lack jurisdiction. This is what Charles Allen Wright says, one of the leading treatise writers on federal practice. The most important difference between venue and jurisdiction is that a party may consent to be sued in a district that otherwise would be an improper venue, and waive its objection to venue if it fails to assert it promptly. This is in striking contrast to subject matter jurisdiction, which cannot be conferred by the parties if it has been granted by Congress, whether by consent, waiver, or estoppel. So to say that a court lacks jurisdiction, that is
means the case is non-existent,
venue
right?
is waivable in a way that jurisdiction, as the term is used, is not. And let's move on, right? So what's clear from the law dictionary is,
wait, do you
if
say
something
the venue? Hold
is
on.
venue on,
You say the venue lacks jurisdiction or the case lacks
jurisdiction as the
jurisdiction?
term, venue is waivable and waive its objection to venue if it has been granted by Congress, whether by consent, waiver, or estoppel. So to say that a court lacks jurisdiction, that is venue is waivable in a way that jurisdiction, as the term is used, is not.
Okay, so he's saying jurisdiction absent of the context of determining whether or not the court has the jurisdiction for a case to be heard. Okay. Yeah, that makes sense. I think I misheard him initially.
And let's move on, right? So what's clear from the law dictionary is, if something is venue, right? If there's a venue rule, if something's dismissed for venue, it is not by definition dismissed for jurisdiction. They are definitionally distinct. Okay? Additional support for P1, right? What's P1? P1 is, if a habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. What's my proof of that? Well, any venue rule is by definition not a jurisdictional rule. So if the habeas territorial jurisdiction rule is a venue rule, then it is not a jurisdictional rule. By definition. That just is what venue is. Venue is by definition not jurisdiction. Okay? Here's the Supreme Court. The jurisdiction of the federal courts, their power to adjudicate, is a grant of authority to them by Congress and thus beyond the scope of litigants to confer. But the locality of a lawsuit, the place where judicial authority may be exercised, though defined by legislation, relates to the convenience of litigants and as such is subject to their disposition. The basic difference between the court's power and the litigant's convenience is historic in the federal courts. And referring in this particular context, Section 51 merely accords the defendant a personal privilege respecting the venue or a place of suit where he may assert or may waive at his election. So what does that mean?
Section 51 merely accords to the defendant a personal privilege rejecting. What does accord mean? And does it have a legal distinction when used in that way? And accord, according to. So whenever you cite somebody, you're saying according to this person, this means this. or they say this and blah blah blah. It's like almost definitionally giving like some level of authority to that person, and then you're citing them with the level of credibility that you're giving to justify or reason something. So to accord, I would imagine, is like a maybe similar in a contextual sense to afford, even though that sounds stupid because they sound similar. So it just sounds like I'm saying that to. Let me type this in real quick. Hold on. What does accord mean? Does it have a difference when used in a legal context? So the general meaning is agreement or harmony. An example would be the countries came to an accord. I feel like I have that. I have heard that in the context of a treaty, so that makes sense. Legal meaning, I would imagine. Wait, before I say anything, if this is just referring to agreement or harmony, it sounds like accord in the legal context, at least in this example, is like granting somebody the ability of something or the right to something, but there's a two-part legal defense or resolution to a dispute over a contract or debt. Accord, an agreement to accept something different, usually less than originally owed. Interesting. Satisfaction, the performance of that new agreement. Okay, so basically what they bargained to, I guess. So when he says merely accords to the defendant a personal privilege respecting the venue or place of suit, which he may assert or may waive at his election. Okay. So is that stating that the two are meeting together to determine which venue is going to be the most appropriate, and that they do have the potential to be able to contest that, and once it's contested, that would be referring to the satisfaction that was given? Okay. There's an example. Let's say you owe somebody $1,000. Okay. You dispute and offer $700. They agree to accept $700 as full payment. So that would be the accord. And the follow through with the 700 would be the satisfaction. So that means the original $1,000 debt is resolved through accord and satisfaction. I wonder if, is that different than settling? Is this kind of... Settlement is any mutual agreement to resolve a dispute without continuing the lawsuit or ongoing trial. It can happen in civil lawsuits, contract disputes, employment claims, etc. Settlement agreements are often formal contracts, and they may or may not involve admissions of fault. Settlements can involve payment, specific performance, dismissal of a case, or any combination. A form of settlement, but more specific to disputes over debts or contract obligations. Okay, so settlement is the broad category. The accord and satisfaction would fall under that broad category, but refer to specifically like payment disputes from what I'm saying or seeing. So this is all under the pretext of the combination of according and settlement, but it sounds like according on its own is referring to the agreement. So according being absent within this definition that Pisco is referencing sounds like it is the agreement itself, but satisfaction doesn't apply here because it's, if it were to apply, then it would be referring to some specific agreement, to like a debt or a contract. But I don't know, we'll see.
Right? Venue is about convenience of the parties, convenience of the litigants, and as such is subject to their disposition. Very different from the jurisdiction of the federal courts, the power to adjudicate. Very different. That's what the Supreme Court says. And there's tons and tons.
Wait, did he explain it?
Courts. I mean, right? Venue is about convenience of the parties, convenience of the litigants. And
Okay, so that would be the accord. And I guess if settlement did exist, which I'll probably end up looking into this a little bit more, if settlement does exist in this context, then the settlement would be referring to the agreed upon venue.
and as such is subject to their disposition. Very different from the jurisdiction of the federal courts, the power to adjudicate. Very different. That's what the Supreme Court says. And there's tons and tons and tons and tons and tons and tons of cases that say the same exact thing. I've only included 3 additional ones here. There are more. There are more cases, additional cases that say exactly what I'm about to show you. This is a district court, federal district court. Venue and jurisdiction are quite different concepts. Oh, look, here's right. You guys probably can't see this very well, but I'm reading it out to you. In a different treatise, all right? This is a different treatise by right. Venue and jurisdiction are quite different concepts. Jurisdiction is a court's power to hear a case. A proper venue is a place where lawsuit is deemed convenient. Citing Nierbo. Where did I get this case that's citing Nierbo? Oh, you just go to the case, Nierbo, and you look at the citing references, and then you can do additional searches, which I did as well. Just because a defendant has conceded that a court has power over him, it does not mean the court would be a convenient venue for a particular case. And when a defendant consents to a court's jurisdiction only impliedly, because of an automatic state law, he has said nothing about the court's convenience. So his consent to jurisdiction has nothing to whatever to do with his rights under the venue law. Nothing whatsoever. Here's a different case. Completely different case. Completely different district court. Jurisdiction determines the instant remand issue, not venue. In fact, the venue of the action is the same location as the one plaintiff selected when he filed his lawsuit in state court, Miami-Dade County, Florida. Right? So what is he saying? The venue relates to geography. Geography. Thus, the critical question is whether this court has jurisdiction over the action. Indeed, the cases cited by plaintiff clearly indicate the difference between an issue of jurisdiction and an issue of venue. The Doe court in Ray Doe specifically held that there is a distinction between venue and jurisdiction. Venue is one thing, jurisdiction is another. They are not synonymous. Venue concerns the privilege of being held accountable to a court in a particular location. Jurisdiction is the power to act, the authority to adjudicate the subject matter. That's what jurisdiction is. Another case from the Fifth Circuit Court of Appeals. Venue is distinct from jurisdiction. Venue may be proper or improper, independent of questions of subject matter or personal jurisdiction. So what does this tell us? If a case is dismissed because of venue, that doesn't mean that it's dismissed because of jurisdiction. You guys get that? Is there anyone here who disagrees? Black's Law Dictionary, the Supreme Court of the United States, other courts interpreting Black's Law Dictionary, the leading treatise writers, and the Supreme Court of the United States. Anyone disagree with that? Anyone think that being dismissed for venue could mean being dismissed for jurisdiction? Is there anyone here who thinks that? Speak up. And so that's my support for P1. If habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. This is a side note. It's not relevant to the argument, but it's so you guys don't get confused. Don't be confused. Just because something refers to, quote, territorial jurisdiction. Look, I even, if you zoom into it, I'll even emphasize. Just because something refers to territorial jurisdiction does not mean it refers to a court's jurisdiction. I don't know if that'll show up on my YouTube. See Black's Law's Dictionary definition of territorial jurisdiction, one meaning of which is simply a geographical reference. Look at definition number 2. territory
Okay, cool.
over which a government, one of its courts, or one of its subdivisions has jurisdiction. All right? That is to
Black's
say,
law.
a definition of territorial jurisdiction can include mere geography. Just because something
Actually,
is...
I think it's actually African American law. I think you're wrong about that, actually. First published in 1891, it has been used by lawyers, judges, and scholars for over a century. The longevity builds trust and consistency in legal definitions. I think it's over 65,000 terms, which is insane. I don't know who I'd even get in trouble by, but just in case, okay? But it's not law. Black's law is not binding. It's a secondary source, meaning it can guide interpretation, but it doesn't create or determine laws. Judges can agree or disagree with it, and sometimes use it as context-specific or statutory definitions instead. Think of black... Jesus. Okay, chill. Chill. Think of blacks like the Oxford English Dictionary. I will not. Thank you very much. Think of this book like the Oxford English Dictionary of Law. Not law itself, but the gold standard for understanding legal language. Okay.
refers to, or the word jurisdiction is used to refer to territorial jurisdiction, doesn't mean that anything that relates to that terminology incorporates what it means to say a court has jurisdiction or does not have jurisdiction. You get that, right? Does anyone disagree with this? How can you disagree with it? It's not relevant to the argument, but it's so you guys don't get confusioned. There are people who look and say, wait, habeas territorial jurisdictional rule, it says jurisdictional rule.
Oh, never mind. Okay. I was going to say that that's what caught me off initially, because contrary to popular belief, I am a layman. Okay? So whenever I first read that, it did slip my mind up a little bit, but it sounds like in this, like a legal context with these, there's like, I don't know how to explain the concept, or if there is like a word to describe the concept. It's just there's different combinations of words in different settings would drastically change what it means to refer to those concepts. So it's like habeas territorial jurisdiction. The word jurisdiction existing on its own sounds like it is referring to the jurisdiction of that venue, because territory is right before jurisdiction. But it's saying the habeas territorial, so I'm imagining those two words as going together rather than involving jurisdiction, the rest of the phrasing. But hold on.
Therefore, it must be a jurisdictional rule. That does not logically follow, okay? Just because it says habeas territorial jurisdictional rule doesn't mean it's a jurisdictional rule. Does anyone think that that's like not the case? Does anyone think that because it includes the words jurisdictional rule or jurisdiction rule, that it's necessarily a jurisdictional rule? Just because it has the words in it.
It just feels so counterintuitive.
Could a case be dismissed for both venue and jurisdiction? Yeah, I mean,
Yes.
you could.
Yes, it could be if jurisdiction doesn't exist, then from my understanding, it doesn't seem like any venue can host it whatsoever if they have no jurisdiction over it, or if there is no jurisdiction that applies to wherever the venue resides at. But the venue on its own could be dismissed, but the case itself still have jurisdiction. So it sounds like if jurisdiction falls off, then if you're referring to a particular venue, then that inherently falls off, from my understanding.
theoretically, okay, yeah, I could say you lack both jurisdiction and venue.
Yeah. Okay, listen. Also, I know he phrases it much more concisely. He is a very sharp guy, and he's very quick and knowledgeable and experienced. So listen, I'm sorry for all the rambling. Okay.
David says, I gotta be honest, I'm barely paying attention. All right, but if you are paying attention, you don't. It doesn't follow that habeas territorial jurisdictional rule is necessarily a jurisdictional rule. It's possible for it not to be, and it in fact is the case. So that's P1. That is, if the habeas territorial jurisdictional rule is a venue rule, then it is not a jurisdictional rule. That's true because venue is not equal to jurisdiction, and dismissing something based on venue is not dismissing it on jurisdiction, as all of this case law, legal treaties, legal dictionaries state, including the Supreme Court. Merrill says, as a linguist, that distinction is completely clear to me, but I might struggle to convey that to others. It's more of an
Exactly, yeah.
instinctual sense of how that functions linguistically. Why do they call it habeas jurisdiction rule rather than habeas venue?
I do wonder why they don't simplify the language, but I wonder if it's since a lot of legal language, and I guess language in general, stems a lot from Latin. I wonder if the translations create the reasoning for this. Venue. Let me sound out in my head. Habeas territorial jurisdiction rule. Habeas. Maybe there's contexts in which habeas and another word always go together. Like maybe like habeas jurisdiction or something. Like if habeas jurisdiction were to go together in place of habeas territory, if that would refer to the jurisdiction itself. And the same thing applies with habeas territorial. Like because those two are paired immediately together. If that is why it refers to it in that specifically versus vice versa.
Wouldn't the latter be way clearer? So that's a reference to, I'm using terminology I'm borrowing like from Kennedy, because the statute refers to respective jurisdictions in it, and that's understood as territorial. Jurisdiction, and that's understood as geography. It is confusing, but it's not a jurisdictional rule, and it is a venue rule, as I'll show you in 2 seconds, Sammy K. But does anyone have a problem with P1? Right? And the proof is in the pudding. Look at all these courts saying you can have proper and improper venue independent of jurisdiction. You can have, here it says it in even the terms, venue is one thing, jurisdiction is another. They are not synonymous. Just because the defendant has conceded that the court has power over him, it does not mean that the court would be a convenient venue. So P1 is pretty based. And you want to have even better support for this notion? Do you want to have even a better evidence for this? Let's go down.
Is it going to be Rob's own
So this
words?
is Mr. Ubercross. He's a lawyer in Rob's chat who Rob often takes his advice. And he's a conservative fan of Rob. And so I checked Rob's stream last night. What did Mr. Ubercross say in Rob's stream? This conservative Rob supporter, fan of Rob. What did Mr. Ubercross say? Jurisdiction never means venue. That's what Mr. Ubercross said. So now, for support of P1, we have the Supreme Court of the United States, the leading treatise writers, courts interpreting the Supreme Court of the United States, Black's Law Dictionary, and Rob's own in-house fan lawyer, Mr. Ubercross. Jurisdiction never means venue. Does anyone doubt P1?
That's rough.
P2, the habeas territorial jurisdictional rule is a venue rule because the Supreme Court has said so. SCOTUS also said as much in Rumsfeld versus Padilla. Judge Boasberg has also held the same. This is what people say, or people cite to me, and they're confused. They're wrong. Of course they're wrong. Quote,
What is Rumsfeld v. Padilla?